much his home as it is her home. And she didn't allow this child to see his father for 6 months. Or like I said, 8 months. It was, and with no regard for the impact that that separation would have on this very young child, who's, I believe, by any account, too young to understand why did dad just disappear from my life. And this was something that we touched on a great deal during the hearing, because frankly, I thought that this showed a shocking disregard for the best interests of this child. To just take a father who's been involved every day of this child's life and just have him disappear because he was a threat to her and her safety? No, because she wanted my client out of their house so she could move her boyfriend in. My client's son had to lose his father for 8 months, and I don't know what he was told during that period of time.
Welcome back to part 2. In part 1, we heard the father's side. Stage for cancer, 8 months blocked from his son, 14-hour workdays, and a mother who moved her new boyfriend into the family home while he was going through chemotherapy. Now the mother takes the stand. And what comes out during cross-examination about the dentist, the shoes, the tube feedings, and the custody schedule will leave you completely speechless. Let's get into it.
All right. Would you raise your right hand? Would you state your name and spell it for the record?
Anne, A-N-N-E, McIntyre, also Clocklin. McIntyre is capital M, C, capital I, N, T, I-R-E, also known as Clocklin, and that is capital C, L-O-C-K-L-I-N.
And do you swear, pardon me, do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ms. Rathburn.
Thank you. Well, Ms. McIntyre, you heard Adam's testimony about the period of time that he didn't see Al due to his cancer treatments. Is that an accurate period of time?
Yes, and it was the midweek visits on Tuesday. He did still try to take him on the weekends.
Okay. And you were willing to work with Mr. Scott to ensure that Al was properly cared for and Mr. Scott was able to recuperate, is that correct?
Yes.
Okay. As for Al's tube feedings, is this something Mr. Scott testified that he's trying to wean him off of the tube feedings? Is that your understanding of where you're at with Al and tube feedings at this moment?
We have always tried to get him to eat. However, because we don't know the cause of why he doesn't eat, we don't know if his body absorbs the nutrients. At this point in time, we are still doing the feeds as instructed 4 times a day.
And are you concerned if Al misses feeds during the day?
I do get concerned because he does not eat enough to sustain himself. I mean, a little bit of meat and, graham crackers or chips isn't nutritionally dense.
Yeah. Is it your understanding from, who's the doctor that's overseeing the tube feedings?
The nurse practitioner we work with is Lindsay Drake at Helen DeVos, and then the dietitian is Maggie Horrigan, and she's also in that same office, the neurodevelopmental office at Helen DeVos.
Now, has Mr. Scott attended visits with you to the nutritionist and the nurse practitioner?
He was at the one last year, but that one was discussing more developmental things. At that point in time, they told us to continue the feeds as scheduled. And then that appointment in June that he's referring to is when he'll go back again.
So here is the tube feeding situation in plain terms. Al needs 4 tube feedings per day, doctor's orders. The father admitted he missed a few during car trips because he was trying to get Al to eat normal food. The mother's concern is real. This child cannot survive on the food he is currently eating without that tube nutrition. But here is the part that matters. Instead of simply calling the father and asking what happened, she saved it for her legal objection. She never once picked up the phone to say, "Hey, did you give him something else to eat instead?" The lawyer for the father called this out directly in cross-examination, and the mother had no good answer for it.
Now, have you participated in any events for Al's school since August of 2024, 2025?
Yes, because of Al's needs and because he does not have a one-on-one paraprofessional, I attend every single school event, even the ones that parents don't normally attend, like our field trip to Robinettes. It was just the kids and the teacher, but because Alan needs more assistance, I met the school bus there, was able to assist him through the field trip. I did the hawk walk, the Halloween parade, where he did not want to march with his class unless I walked the whole parade with him. But yeah, any sort of special day that throws his schedule off at school, I make sure I'm there just to offer him support.
What about his birthday? What did that look like for a school activity?
On birthdays, because we don't do food, they do hand out, usual little goodie bags. Because Alan has a love of tornadoes, I made goodie bags that had a tornado tube in them where you attach the pop bottles and the kids can make their own tornadoes at home. So I brought the goodie bags, I printed out all the instructions. He gets to stand up on a chair and they sing him the little birthday song, and then he gets to pass out his goodie bags to his friends during snack time. Just a special thing that they do for kids on their birthdays.
Now, have you been, you listened to Mr. Scott's testimony about having extra shoes at school for Alan. Was it an issue with him only having boots at the school about 3 weeks ago?
It was, his teacher brought,
You can't.
sorry.
You can't say what she said,
Oh,
but to your
okay.
understanding, was it made
Yes.
an issue?
Yes.
Do you know what happened with the shoes that he had at school?
No, I found one in the lost and found. I have no idea where his shoes went.
So have you provided more shoes for him to have at school?
Yes, 2 pairs actually. So she has one set aside under her desk in case the other pair goes missing.
Okay. Now, have you had concerns about how this schedule's been going once it was implemented week to week?
Yeah, because it was very abrupt. And it separates him from his siblings, which was a little concerning to me, and it's concerning to them too. They're teenagers, but they still are like, oh, okay, he's just
Well, you can't
gone.
talk about
Oh,
what they
sorry.
do.
Yeah,
No.
just separating from his siblings was a concern.
What about how Alan's been reacting to the new schedule?
He's okay. He's always very happy to come home. He's always very tired. He usually sleeps a lot that first night, and then we get back into our normal routine after that weekend of adjusting.
Okay. And I mean, is it still your position? Obviously, we filed this objection. What do you believe would be in Al's best interest as far as the schedule goes?
I was in full agreement with friend of the court and what they recommended, because that kept Alan and his other siblings together. So that they would transition together. It just seemed more cohesive to me.
Did that schedule allow you to be providing additional care for Alan with your schedule versus with Mr. Scott's?
Yes, because most of the days off he has from school are typically Fridays, and all the kids are home by Wednesday. So, and a lot of times on Friday, I just work from home, if I even work at all, because sometimes I can get everything done before Fridays.
Now, is it accurate? I asked Mr. Scott the question, is it accurate that his ABA therapy is going to change up this summer?
Yes, because currently he goes on Monday and Wednesday, but when we start therapy and fun, that will be Tuesday, Wednesday, Thursday. So we will have to rearrange the ABA schedule to fit with therapy and fun.
Is it your understanding that the ABA therapy that Alan qualifies for, that they'll increase his home-based hours?
Yes, they have the ability to do that, especially over the summer, to help with continuation of learning, and so that there's no loss of skills while he's out of school.
And then, do you have issues with the meeting spot at 28th Street?
Maybe not so much the spot, but the time, you know, the time at 6 p.m. And it just seems that both of us are going out of our way to get over there when we could be exchanging just at school or ABA or daycare or what have you, instead of, you know, having to go all the way out there at 6. And also, you know, we have to get right home, and then he's only home for a few minutes before we can start the last feeding tube of the day. And I was just hoping we could find a smoother way to do transitions.
Now, Mr. Scott complained at the end of his testimony that you're not communicating with him. And he brought up the dentist appointment as an example. How do you respond to that?
I forgot that the appointment was scheduled until they called me the day before the appointment. And because I also had a cleaning simultaneously, like Alan and I were both getting our teeth cleaned at the same time. I just took him to the appointment and brought him back to school. And then I updated Mr. Scott, hey, his teeth are good. You know, I was already going to be there to have my own teeth cleaned. And it was literally, I just forgot till they called me. And given that I live 5 minutes from school and the dentist is much closer to our home than Mr. Scott's work, I mean, it wasn't to be a slight. I just know he is not happy with the amount of driving he has to do. He makes that clear, and a lot of communication. I didn't think he'd want to sit there with me while I got my teeth cleaned. So if there was anything major, I would have called him, you know, right then and there if they had to do anything, but it was literally just cleaning his teeth.
In the future, do you understand that you have to let Mr. Scott know ahead of time of
Yes.
any appointments if he's not aware? Okay. And would you have any disagreement if he took him to the next dental appointment?
No, that's fine. I'm driving there myself to have my own teeth cleaned, and I honestly don't know whose day it is at that point in time. If he wants to meet us there, that's fine. If it's his day, he can take him, but
As to his Mr. Scott's testimony that you refused to talk to him about things regarding Alan, do you say that that's true?
The dentist appointment. The mother forgot to tell the father. She was already going for her own cleaning. Took Al, brought him back to school, and only mentioned it to the father at pickup. No cavities, nothing major. But the father never knew it was happening. Now the mother says it was an honest mistake. She forgot until they called her the day before. And honestly, that is probably true. But that is exactly the problem. These two parents are so disconnected from each other that basic appointments, things that any co-parent should automatically share, are falling through the cracks. And a child with special needs cannot afford for his parents to be this disconnected.
yeah.
Okay. Is that something that Mr. Scott has raised the question with you and you've not discussed?
No, this is the first I've heard of it.
Okay. And his request to use Our Family Wizard, are you familiar with that app?
Yes,
And you've used it before, correct?
correct.
Do you think it's necessary in this case?
I do. It was part of the friend of the court recommendation as well.
Oh, okay. So you're in agreement to implement that. Okay, great. I have nothing further, Your Honor.
All right, thank you. Mr. Carpenter.
Thank you, Your Honor. I'm sorry, I want to call you by the name you're using. It's Miss McIntyre now?
Yes.
Okay. Miss McIntyre, did you reach out to Adam when you received the unused tube feeding supplies back?
No, because Mr. Scott had sent me an email stating that he did not do all the feeds.
Okay, did he explain why?
He just said he was busy driving, but I feed him in the car every single day with the feeding pump. I take it with me to work if I have to, so that if we have to drive somewhere or if we have an event after school, I can hook him up and he still gets fed.
Okay. So was there even an attempt by you to communicate with Mr. Scott that you thought he should have been giving the tube feedings, or to ask if he had been given alternate food? How did you work through that?
Given that Mr. Scott has attended all the appointments with the dietitian, I assumed he is aware that he needs to be feeding his child the
Well,
TVs.
do you disagree with Adam's testimony that you guys are supposed to be introducing quote unquote normal food?
Which we do, but you know, I volunteer in the lunchroom. I watch him. He does not eat any food during the school day. He might play with it, but he doesn't accept multivitamins, like no gummies, no anything. So if he doesn't get his complete nutrition, you know, it's a little concerning. Food at this point is more of an introduction to see if we can even find things he likes. And at this point, he doesn't eat enough food to you know, stay healthy.
Okay. Would you allow for the possibility that Adam is having better luck getting your son to eat normal food than you have been?
He has never communicated that. If he would give me a full list of everything he eats, because yeah, like I said, he is exposed to the lunch and breakfast at school. You know, he will eat pork chops. He will not touch any vegetables or fruit. Sometimes I got him to eat 2 bites of a banana at school lunch the other day. But no, I mean, the most we do is offer him what we cook for dinner and encourage him to eat with us and his siblings, but
Yeah, I'm gonna ask you this again, and I want you to just answer my question, please. Would you allow for the possibility that Adam is having better luck getting your son to eat normal food than you have been?
yeah, it's possible.
Okay, isn't this a situation where you should have communicated with Adam regarding these concerns rather than saving it up for your objection?
I was not aware that he was feeding him. I would love to know what he can convince our child to eat, because
Wouldn't you agree this
any
is
luck.
a perfect example of the two of you not communicating? I mean, you were concerned about him not getting his tube feedings, but instead of talking to Adam about it, you just put it in your objection and never said a word to him.
I
Wouldn't
did
you
not
agree that's what happened?
feel. I can't hear.
Okay, have him repeat that.
Can you repeat it? I can't hear. I'm sorry.
Wouldn't you agree that this is an example of you failing to communicate with Adam by not sharing your concerns with him about your son not getting all of his tube feedings?
No,
Well, do you have any reason to suspect that Adam wouldn't tell you about the food he's giving your son if you would have talked to him about it?
I was not aware he was feeding him. He never told me.
But you put in your objection that he missed some tube feedings, but you never talked to him about why he missed them.
He told me in an email he missed the feedings because he was driving. I
Okay,
didn't
fair.
see the point of having an argument with him over it. He told me point blank that's what happened.
Okay, fair enough. How old are your other children that live in the home?
16 and 13.
Okay, so you would concede that your son is going to have a relationship with a dependent relationship with his father much longer than he's going to have a in-home sibling relationship with your teenagers, right?
I'm sorry. I'm not sure I'm understanding.
But your suggestion to the court is that your youngest, that Al should be on the same schedule as his teenage siblings, correct?
Correct.
Don't you think it's more important that he have a good relationship with his father, given his young age and the fact that the teenagers are sort of at a different phase of life?
My children still interact all the time. I mean, my daughter is his favorite person. they play games together, they do activities together. It's not like they are two separate families.
I understand, and I'm not trying to argue with you. I just want to flesh out where you're coming from, because are you suggesting that Al should have less time with his father so that he can have more time with his teenage sister?
I feel like my children should stay together as a family unit because they are siblings. They are not they're siblings. And this is, what Alan was used to, what our family was used to. He still sees his father. He still has lots of vacation time with him. Where the other children are with their father. Purely just day-to-day things. To me, it makes sense for him to be with his siblings if at all possible, because that's what was normal for him.
So your answer is yes, you do believe that Al should have less time with his father so he can have more time with his siblings?
I believe my family unit should be as intact as, and there's no nice way to answer this. So I guess, yes, I believe he should stay with his siblings, but not out of hate or spite for his father, just what's best for him in his day-to-day routine in life.
And there it is. The mother just admitted on the record that she believes Al should have less time with his father so he can have more time with his teenage siblings. The lawyer for the father did not let that go. He pressed her. Are you saying a child's relationship with his father should be sacrificed for more sibling time? And she said yes. That answer right there may have just cost her this entire case. Because the court's job is to protect the child's relationship with both parents. And when one parent openly says the other parent should have less time, judges notice that. Every single time.
Your Honor, I think I got everything I wanted to get from my client. He did recall that the reason he didn't provide snacks for Al's birthday is because Al had ABA therapy that day. I can recall him to testify to that if people don't want to simply accept my representation. But that's
Ms.
about the order.
Radburn?
I don't object to Mr. Carpenter placing that on the record, Your Honor.
Okay,
Okay, so with that, I really don't have any additional witnesses, Your Honor.
okay. And then we'll move to closings.
Well, thank you, Your Honor. I filed this objection on my client's behalf because, for one, I knew upon reading the referee's order that there were discrepancies from what I recall was presented at the hearing versus what was indicated as facts in the referee order. And then also it's my client's base belief that she does not present that she doesn't want Mr. Scott to have any time with his son. It's just that the additional days that he was asking for to make it an equal schedule, more or less, was more for Mr. Scott's benefit than for Alan's benefit. And the focus of this case is supposed to be Alan. He's a child with a lot of special needs. He has a feeding tube. He needs to be fed 4 times a day by the feeding tube. Today's testimony did not expand on that any, that the doctor has said, well, you can go ahead and skip feedings and if you find this food process. I don't think Mr. Scott testified that. He said this is a goal, is that we're looking for doing this. But I think it is still concerning that because Mr. Scott is intent on making this such an equal proposition, that he's unable to provide the sustenance that Alan needs on a day-to-day basis. He skipped feeds. He had too much time in the car driving from Caledonia to his school, to his work. And these were the arguments we placed on the record at the time of the hearings. And so I wanted to present, and I'll go through this now, is that I took some notes with the referee order that specifically we found issue with, that I think affects how the court should be re-looking at this order and revising it potentially. Right away on the referee's order on page 2, she indicates that the plaintiff spent every night with his son. And but then, actually, I'm gonna skip that one. I'm just gonna cross that one off. We're gonna move on to the next one. I think one of the big things that the referee pointed out several times is that the parties were not following the order. The temporary order that they had entered back on 10/14 of 2024 was in fact followed. And the referee picks up this thread on several pages. She picks it up earlier on in her overview, and then it comes up again. Where on page 11 of the order, any other factors, the parties were not following along with the court order. And she references this, that they were exercising some schedule with my client 9 days on and then 5 days off. And then she talked about a different schedule with Tuesdays and whatnot. And it simply was incorrect. At the time that the parties presented testimony and evidence on the record, from this 2/17/2024 transcript, page 11, lines 14 through 17, Liz Hayes testified about the parenting time for my client's older siblings. And it's how I'm looking at this, is that referee Kessler actually took that testimony and applied it to the parties instead of hearing that it was what the older siblings' schedule is. And so it's never been a point in contention that was testified during the hearing, is that my client was deviating from that temporary order from 10/14 the entire time, and that didn't happen. They've always followed that order. And I think that's again where referee touched on it on page 11 of the order, saying anything else when she was looking at any other factors. And then she brought it up again too with arbitrary compliance with court orders on page 11 of her order. Again, raising this issue that my client was deviating from the court order when that had not occurred. So I think that's a pretty major issue that came up 3 different times in the referee's order of her deviating from a court order, and she never did. Another one that I'm looking at as far as discrepancies is in when referee evaluated the factors. In factor A, she gave Mr. Scott preference because my client would not follow up with communication between the school and the plaintiff for conferences. She isn't trying to strengthen the emotional ties between him and her son. And actually, in the transcript from April 30th, 2026, Mr. Scott testified that he knew that he had to get information from conferences, not from Power School, but that he had to send an email to the school. And he admitted, I mixed up the emails. That's on page 65, line 20, well, no, page 64, line 24, and then page 65, lines 1 through 2. And it also came up in my client testified about that issue on 2/17/2025 transcript, page 42, lines 6 through 11, that he had access to the information. And she also testified that he got information per the school newsletter. That's on the same page 42, lines 20 through 21. And so I disagree with the referee scoring this in Mr. Scott's favor about the love and affection and other emotional ties existing between the parties and the child, and blaming my client for not forwarding email communication when Mr. Scott testified on his own behalf that he had messed that up. I think that factor should have been scored equally. I also have an issue with how the referee scored factor K as far as domestic violence. She gave a slight advantage to Mr. Scott on that because she indicated that she didn't find my client's testimony about domestic violence to be credible, but the referee left out the fact there was in fact an active personal protection order that the court signed and granted for my client, which is something that does need to be evaluated in regards to domestic violence. And I would argue if she didn't find my client trustworthy or credible with her domestic violence claims, then maybe that factor should have been scored with no advantage to either party. Because then it's specifically looking at domestic violence. And if she didn't find my client credible, that could have been scored in other areas, but that was not the case. When she's looking at the parenting time, oh, and then the other issue that I wanted to raise with the court is is holiday parenting time. The referee determined, and it was on towards the last few pages of her. I think it was on the last page, yeah, page 13. She talks about in regards to holiday parenting time, there was no argument made that the recommendations made by FOC were inappropriate. However, my client presented an exhibit, and this is where I was concerned that none of the exhibits were referenced in the referee's testimony or order that she had reviewed the evidence, is that was exhibit number 2. My client had drafted up a proposed argument or a proposal for parenting time that included holiday parenting time. And the holiday parenting time showed the rotation of what the other siblings are on. And so that's in the transcript 2/17/2025, page 33, line 4. That was exhibit number 2. And then further, my client testified about it again, about holiday parenting time on the 2/17/2024, 2024-25. But the February 17, 2025 transcript, page 45, lines 12 through 15. She again testified about how she wanted the parenting time to line up. And then further, Mr. Scott actually testified on 2/17/2025 on page 59, lines 13 through 15, that he agreed to line up the holiday rotation with Miss McIntyre's other children. And since the entry of the order, the parties have discussed this further, and they are in agreement again to continue the proposal that my client had as far as parenting time. And so, Your Honor, in addition to the testimony today of Mr. Scott, and it's not that his illness is something that I'm looking at that but I want to make that a negative thing, but I think it's a realistic thing to acknowledge that he had that going on and he missed 2 months of parenting time. Also, his testimony today is again about how his schedule is very hard for him to manage, and that Alan has specific needs such as ABA in-home therapy that Mr. Scott cannot accommodate with his current living arrangement. And that's pretty concerning that ABA won't be able to be in his house at all this summer. In addition to the ABA therapies that are going to be from 9 till noon, that I know my client will work with him because she's going to do whatever she needs to in the long run to ensure that Alan's needs are met. But this is just another reason why overall we felt that an exact 50-50 schedule was not addressing Alan's needs in the best manner. And it shows up again as far as my client volunteering at the school where Mr. Scott cannot. And and I understand he needs to work and he needs to do these things, but for the parent, for my client, she's there and she's providing the shoes and she's taking care of the goodie bags that need to be handed out. And I feel like that was not really acknowledged by the referee throughout our hearing. And so, Your Honor, it is our proposal that the court adopt the friend of the court recommendation, which gave Mr. Scott just a little bit less time. And it's just to acknowledge the fact that my client who's at home and has a flexible schedule can be the one to jump up and be there at school when Alan needs shoes or when Alan needs someone to be there to help him be in the parade or not be in the parade. And that having this 50-50 schedule on paper, which maybe makes Mr. Scott feel better, and it really shouldn't affect how he parents, because he does a fine job. That's never been anything my client says that Alan is at risk, although missing the feedings is concerning and she would want him to continue that. I just think it still is not in Alan's best interest, Your Honor. So we'd ask that the court revise the referee order, adopt the FOC schedule and my client's schedule for holiday parenting time. Thank you.
Thank you. Mr. Carpenter.
Thank you, Your Honor. Obviously, there was a great deal of hearing in this case. We had several days of testimony. Referee Kessler is a very experienced judicial officer. She's been doing this for a very long time. And Ms. McIntyre is well represented. I will concede that. But Ms. Rathburn seems to be focusing on details that really don't affect the overall picture that Referee Kessler arrived at here. One of the main concerns that Referee Kessler had is, and it was borne out by the testimony here today, Ms. McIntyre simply doesn't respect the parent-child relationship between Al and his father. And how do we know this? Well, for one, she testified to it today. She thinks that my client should give up time with his son so that Al can have more time with his siblings. She didn't really go into detail there, but I think that's really the underlying issue here. But it's important to back up and look at how this case began. You'll note that referee Kessler mentioned several times throughout her opinion that Miss Conklin has bragged to people that, she's a social worker and she can social work her way out of anything. And we have several examples of her basically manufacturing problems in the co-parenting relationship in order to support, I guess, tenuously at best, her request that she have primary physical custody. I heard my questioning about the missed tube feedings is, I think, emblematic of that. Your Honor, this child, according to the testimony, has 4 tube feedings per day. In all the months that the parties have been exercising this schedule, Al's missed 3 bottles of food. And this is made out to be some crisis. But the real issue here, and when I questioned Miss McIntyre about this, she didn't even talk to my client about it. She noted that some of the tube feeding supplies came back that they hadn't been given to the child. And she says, well, my client said that he was too busy or he was driving or something like that. But she admits she didn't talk to him about it. She didn't say, well, did you give him other food in place? And we're talking about a de minimis amount of missed feedings here. But she, instead of talking to my client and working through it the way you would expect co-parents to do, she saves that for her objection and puts in there that, well, my client's missing tube feedings, so therefore she should have more time. My client should have less time. And I think that's part of the problem here. But this case started out with, and again, I don't want to engage in a bunch of mudslinging here, but Miss McIntyre had already found a new boyfriend. She used a personal protection order to throw my client out of the home that they bought together, that is every bit as much his home as it is her home. And she didn't allow this child to see his father for 6 months. Or I guess 8 months. It was, and with no regard for the impact that separation would have on this very young child, who's, I believe by any account, too young to understand, why did dad just disappear from my life? And this was something that we touched on a great deal during the hearing, because frankly, I thought that this showed a shocking disregard for the best interests of this child, to just take a father who's been involved every day of this child's life and just have him disappear. Because he was a threat to her and her safety? No, because she wanted my client out of their house so she could move her boyfriend in. My client's son had to lose his father for 8 months, and I don't know what he was told during that period of time. But again, that is a shocking disregard for this child's relationship with his father. Who knows what that child was thinking? Where did my dad go? Why can't I talk to him? My client couldn't even reach out to try to talk to his son because he had a personal protection order. He'd have gone to jail for even attempting to communicate with his son. And again, Miss McIntyre is a social worker. She tells everybody who will listen she can social work her way out of anything. Well, she can social work her way into things too. But again, at some point, the court has to be concerned with what level of respect does Miss McIntyre have for the relationship between this child and his father. I think that the schedule that Ms. Kessler arrived at is the best way to address that. Do I wish the parties would communicate better? Certainly. And I realize that I'm on my client's side here and I tend to empathize with him, but I think it's pretty clear that he's willing and able to communicate and co-parent. And the resistance is coming from Ms. McIntyre's side. If she wants to have better communication regarding tube feedings, well, then she's going to have to talk to my client. But I get the feeling that she's more interested in using missed tube feedings as an excuse to engage in litigation or perhaps to strengthen her case than she is in actually seeing to it that the child is getting his nutritional needs met. And again, my client's understanding is that the tube feedings are not permanent. that the goal here is to transition the child to eating normal meals. My client's working towards that goal. I didn't hear any testimony like that from Ms. Conklin. I'm sorry, I'm interchangeably using, I didn't hear that from Ms. McIntyre. And again, Your Honor, when we're dealing with the best interest of the child, it looks to me like Ms. McIntyre is more interested in reducing my client's overnights than she is in addressing any specific concerns. If she thinks that fever tube feedings will be missed by reducing my client's overnights, well, I mean, I guess that's an argument that could be made, but I don't think she connected the dots. It looks to me like she's counting overnights. And that shows a disregard for the child and his needs. As my client testified today, there was a period of transition. He even admitted the child struggled a little bit for a couple of weeks with that period of transition, but now he's doing great. I have raised a couple kids myself. They don't have special needs and they didn't require tube feedings, but anybody who's raised kids, especially more than one kid, knows sometimes the kids are going to eat at 9 or 10 o'clock at night. Sometimes kids both have soccer practice or a soccer match in the same night, and your schedule gets disrupted. That happens. That's not a reason to limit the child's time with his father. He's going to miss time. He's going to miss feedings in Miss McIntyre's home too. I'm sure he has. But my client isn't keeping track of that to try to use it against her, so I really don't have any of that information. But it's not really possible to keep a child on a consistent schedule all the time when they have other activities and things that they have to engage in. So I believe that Referee Kessler's order was appropriate. You can try and take issue with certain tiny details regarding her findings of fact, but I don't believe any of these are facts that affect the ultimate outcome. I don't believe that Referee Kessler would have changed her recommended order if she had been reminded that there was some discussion of the holiday schedule during the trial and these other sorts of detail matters. I think she still would arrive at the same result because, again, and I'm not here to mudsling, but Miss McIntyre simply doesn't respect the relationship between this child and his father, and the best way to address that is to maximize the child's time with both parents. The recommended schedule does that. And so we would simply ask that Referee Kessler's schedule be affirmed and that the order continue in place as is. Thank you.
And that is the full picture. A father who battled cancer, lost 8 months with his son, and is now fighting to protect a custody schedule that the referee already approved. A mother who is a social worker, who knows exactly how the system works, and who used a protection order not for safety, but to clear the path for a new boyfriend while her son's father was going through chemotherapy and radiation. The referee's order gave both parents equal time. The mother objected. And after everything this court heard today, the missed feedings that were never discussed, the dental appointment that was never shared, the admission that she wants the father to have less time, the question for the judge is simple. Who is actually putting this child first? If this case had you as fired up as it had us, hit that like button, drop your thoughts in the comments. Did the mother go too far? And subscribe for more jaw-dropping courtroom breakdowns. New cases every single week.